Now, everyone, I hope I will be able to get anyone please tell me.
हाँ वालेकुम सलाम खान साहब थोड़ी सी अब आपकी आवाज़ कम आ रही है तो आवाज़ लाउड रखें
Acha, am I audible now?
परफेक्ट नाउ
Thank you so much. So I warmly welcome you all again on our virtual workshop on alternative dispute resolution. So building upon our introduction, our second session will focus on various modes of alternative dispute resolution. We will mainly explore mediation, arbitration, and negotiation, and other alternative methods which are used for resolving conflicts. So, through real life examples and case studies, we will analyze the effectiveness and suitability of each. So, this session will be held by Mr. Ghulam Mohammad Adnan. So, I would like to introduce himself. So, Mr. Ghulam Mohammad Adnan is an international mediation institute qualified and Singapore International Mediation accredited mediator. Having received his initial mediation training at in the Universal College Lahore ADR initiative, where he served as the joint secretary and then the vice president, he went on to qualify as a mediator from ADR ODR International. Thereafter, he completed numerous mediation training courses, including the 40-hour basic mediation training conducted by Kathleen UNPD with Mediate Group. He is currently listed on the panels of ADR, ODR International UK as a foundation professional. And routinely, Mr. Adnan coaches individuals and teams for ADR competitions all around the globe. He regularly sits as an expert assessor in mediation competitions internationally, such as Bucharest Mediation Competition, ADC ICC Asia Pacific Commercial Mediation Competition, and ALSA International Mediation Competition, Mediate Group Virtual International Competition, to name a few. So now I would like to call Mr. Ghulam Mohammad Adnan to lead this session, and I would like to hand over the mic to him. Thank you, sir, for joining us. We are really grateful.
Thank you very much, Khan Saab, for that lovely introduction. And thank you very much, Ehsan and Ahmed, for trusting me with this workshop. By way of your introduction, Assalamu alaikum, firstly, everyone. I am Ghulam Mohammad Adnan, and I am delighted to be the trainer for today's workshop. Just some disclaimers from the outset that I would like all of you to note is that a 1 hour or 1.5 hour workshop would never be able to do justice to these three processes of ADR that we have in front of us today, namely negotiation, mediation, and conciliation. But at the same time, I'm going to try my level best here to get you all rolling and give you a brief introduction of all the processes. But that does not mean that this is going to be not as comprehensive. It is in a way going to be the equivalent of drinking directly from a fire hose, if you want to put it that way. Another disclaimer would be that I'm not really going to be focusing on the legal framework as such in Pakistan. Yes, we do have some points which I'm going to raise there, but it's not going to be a comprehensive guide as far as the legal framework of Pakistan is concerned. No workshop should proceed forward without introducing your teachers who have trained you and put you in the position that you are. And for me, it has been 3 or 4 people who I would really like to mention here as my mentors would be Mansara Tariq from ICLS, Rahim Shamji, then there's Bruce Edwards from Edwards Mediation Academy. Rahim Shamji is from ADR ODR International. Then Professor Dr. Tariq Mahmood, he's currently working as a barrister in the UK. And then, of course, Dr. Nudrat Ijaz Parata. So these people are some lovely professionals who have guided me in my journey and have brought me to the point where I am today, sitting here and sharing my experience with you all. These are the slides that we are going to look at, and it's we have around 29-ish slides that we are going to go through today. And again, primarily focusing on negotiation, mediation, and conciliation. You have my name, email, contact number, and my LinkedIn address there. I'm going to also request Essen to share these slides in the group after we're done with the session. So please feel free to get in touch with me and connect with on LinkedIn. And I hope to remain in touch with all of you. We've heard from Khansa about my introduction. You can read the same on the slide as well. But quickly moving on, here's the agenda for today's session. So any workshop on ADR, I think, cannot proceed forward without the question, why ADR? And why do you want to come to ADR to resolve disputes? And I'll briefly address that because I don't think it can be done any better than it has been done by my lovely colleague, Mr. Ahmed, yesterday. But then we're going to quickly move on to negotiation, looking at the different approaches to negotiation, comparing the different approaches, then mediation, the stages therein, the advantages of mediation, how an agreement arising out of a mediation can be enforced. Then we look at this very short debate or whether a mediator should or should not propose solutions. Then we are going to look at how is conciliation, primarily about how is conciliation different from mediation, and to bring some international flavor on how mediation and conciliation operate in an international framework. We're going to look at conciliation primarily under the ICSID rules, that would be International Center for Settlement of International Disputes. Then we are going to look at the advantages of conciliation, which are essentially the same as mediation, but have two further points added to them. Then we are going to look at the ADR continuum, a very fancy word as it sounds, but it's really just a graph to show you in perspective how these different methods compare to each other. Then we are finally going to come to Pakistan, the enforcement mechanism here, and then the numerous centers of ADR that we have in Pakistan, one of which is obviously the Young Mediators Forum, who are collaborating with Lowitz to come and have this workshop for all of you. Then some suggested trainings that I have for all of you, a brief list that I have compiled for those of you who are interested in moving forward and carrying ADR as a career. And then some tips for both professionals and for students on how to proceed forward in one of these three domains. Then while I was attending Ahmed's session yesterday, I came across some arguments in the chat. And again, these were not some really novel arguments. We have always been hearing them from the outset. And we are going to look at some arguments against ADR, and I would make a humble attempt to put my perspective on those positions. And then some issues very briefly that I think that the ADR framework in Pakistan currently encounters. So quickly moving on. Why ADR? So as we are all aware, we go to court for a litigated case, we go for litigation in the court, and mostly there would be a winning party and a losing party. There would be a right party and a wrong party. ADR essentially takes the burden, especially the three methods that we're going to talk here about, essentially take that burden away and give both the party an equal floor where none of them is right and none of them is wrong. Both of them are equally empowered to make their decisions, to reach an amicable settlement. And I think that literally really does relate to this quote from Rumi here, where he says that out beyond ideas of wrongdoing and right doing, there lies a field. I'll meet you there. And for me, this is where ADR actually lies, especially the three methods that, again, we are talking about today. Then this quote from the 15th Chief Justice of the United States, who says, and I quote, "Our system is too costly, painful, destructive, inefficient for a truly civilized people. To rely on the adversary process as the principal means of resolving conflict claims is a mistake that must be corrected." And how do we correct that mistake? How do we develop a system that is not adversarial? Well, ADR. ADR is that system. And again, when I say ADR, I'm primarily going to be talking about the three methods here and not about arbitration and other methods that are going to be discussed later in the workshop by our lovely colleague, Mr. Hasnan. Then I think it relates to this quote from Justice Mansoor Ali Shah of the Honorable Supreme Court of Pakistan at a seminar in Lahore, where he states, and I quote, "Litigation is a scenario in which you go in as a bull but leave as a sausage." Now, why is that? Is because one, costly, time-consuming, emotionally, mentally draining. For those of you who have been to courts, you must have seen really ugly situations where, especially in cases of family issues and child custody cases or divorce proceedings. So you go in as a bull, you're like, all right, I'm going to tackle this, I'm going to butcher the other party, but in the end, you are the one who gets butchered and who comes out as a sausage. So that's why people like me, Ahmed, Ehsan, and numerous others are of the view that ADR is the way forward and should be implemented and really followed throughout the world. This brings us again to one of the first topics that I'm going to discuss today, and that's negotiation. So there's no as such definition of negotiation, if I say, but it is essentially really a dialogue between parties to reach an agreement. And if I quote an extract from this amazing book by Roger Fisher and William Murray from the Harvard program on negotiation, Getting to Yes, it says negotiation is back and forth communication designed to reach an agreement when both of the parties have some interests that are shared and others that are opposed, as well as some that may simply be different. Again, to put that into perspective, you go out, you want to buy a car, your interest is that you want a car at the lowest price and you want the best car at the lowest price as the buyer. The seller's interest there would be he wants to sell his car and he wants to sell it as high as possible. So there you have those competing interests. And now both of you are going to negotiate on these interests. The seller is going to demand his interest and defend that, and you as the buyer are going to defend your interest. So that's essentially where negotiation takes place, and obviously there would be offers, counter offers, and whatnot. So again, negotiation utilized on a daily basis, but it is an often ignored reality that we utilize ADR literally every day. Be it discussing salary on a job appointment, purchasing fruit from the market, buying a car or a used car or a house, setting lawsuits as lawyers do, government officials dealing and talking with protesters, as we always see in Pakistan a lot often, foreign ministers of different countries sitting to seek an agreement on bilateral ties, and literally even the smallest things such as sitting with your spouse or even your parents and conversing on what you want to have for dinner. Well, you want to have roti, they want to have rice. Then you negotiate. Well, why roti and why rice, right? And you put your perspectives and those competing interests to try to reach an agreement on that. That is negotiation in a nutshell for you. Now, there are different approaches to negotiation, and primarily it's these two, the traditional ones. There's the soft approach and there's the hard approach. In the soft approach, the negotiator aims to avoid any conflict and readily makes concession to reach an agreement. So to put that into perspective, the eldest child in the family. So you might have seen quite often that the eldest child would be like, all right, I'm going to give up the toy for my younger brother, or I'm going to give up my food for my younger brother, my younger sister. So that's where you would see a soft negotiator. Or even if we put that into perspective, our lovely mothers and our parents. So let's say we want something, they don't want us to have it. More often than not, they would compromise just to avoid conflict and would make a concession and let you have that thing which you want. So that there is a soft negotiator. Now, the disadvantage here would be that the negotiator may be exploited easily. So let's say your parents are soft negotiators and they make concessions readily. What if one day you want to do something illegal, right? What if someday you say, well, I have 3 brothers and I want the entire property to myself. So this way you would be making an attempt and you can actually exploit that negotiator, right? So that's where the hard approach comes in. So the negotiator takes a hard position or stance on what they want and really makes any concession at all. Such negotiators see negotiation as a battle which they want to win. So to put that into perspective, when our parents don't want us to do something wrong. So let's say you say, well, I want to go have a beer today, and you belong to a Muslim household. Well, your parents are definitely going to take a hard stance there. Or to put that into further perspective, the youngest child in the family. If they want something, they want something, right? So that's where if I can put the easiest way I can put these two into perspective. And again, the disadvantage here would be that the relationship with the other party would be harmed for if you take a hard approach always. So let's say you're that adamant child who wants what he wants and does not want to listen to the other party. Well, you're going to harm your relationship with the other party, whether it's your parents or your siblings or whoever it is there. Just give me a second. Please excuse me for just a brief moment. All right, apologies for the disruption. So, so your relationship with the other party would be harmed, and again, that would not be beneficial in the longer run. But apart from that, I think so. If we say that you have two negotiators who are soft negotiators, then I don't think it would be an issue as such. Both would be making easy compromises, easy concessions, and thus the relationship would be preserved. But the issue then arises if you have one negotiator who takes a hard approach and one who takes a soft approach, or where both of them take a hard approach. So let's say you have two negotiators, and one takes a soft approach and one takes a hard approach. Well, the one with the soft approach is going to get exploited. Whereas where you have both negotiators as hard negotiators who take a hard approach, then the chances of reaching a deadlock are significantly higher. So let's say you say, well, so let's say again, you go to buy a car, you say that I want to buy it for, let's say, 1 million rupees. Well, the other person says, no, I'm going to not give it for any rupee lesser than 2 million. And you both are stuck on this. What is going to happen? You're going to be in a deadlock, right? If you both are hard negotiators and you do not move from your position. The deadlock essentially is when no progress is being made in negotiations and both parties are stuck on their position. So that's a disadvantage of a hard negotiator, two hard negotiators competing with each other. So how do we remedy that? What do we do? Well, we have the solution, which is a combination of both soft and hard approach. And this is essentially termed as principal negotiation developed by the Harvard Negotiation Project. Now, it is there to discuss this negotiation way of negotiation. The Harvard people do it in like 4 to 5 days, and they spend the entire 4 to 5 days discussing just this approach. So for me to come in and try to sum it up in a session in 1.5 hours or 1 hour would not be possible practically. But I have listed the key points in this approach, which you can look at, and I will briefly explain all of them to you. And then I have recommended a book which you can read to further distill these and learn more about them. So firstly, separate the people from the problem. So this is essentially, if I put that in a nutshell, it is letting them know that this is not against you. The negotiation is not you versus me. It's you and me against this issue, against this competing interest that we have, right? Then focusing on interest, not position. So just saying that let's use that orange example which Emma gave yesterday. So let's say one child wanted the orange for the marmalade, the other wanted it for the juice, right? Now, if one says that I just want the orange and I don't care about the other party, I just want the orange. Now that is position. Now, if they say I want the orange to make a juice, now that's their interest behind wanting that orange, right? So for negotiators, it's best to focus on the interest that I want that orange for juice or marmalade, rather than focusing on the position that I want that orange. Now, again, to further understand that, you can read the recommended reading there, and then inventing options for mutual gain. So this is essentially both of you coming against the problem, that is that orange. Not that orange, but in fact that one orange. Because if you had two, you could essentially distribute them. You have one orange and you want to invent options for mutual gain and how both of your interests can be taken into account and catered to by that one orange. And then insist on using objective criteria. What would happen if, let's say, someone else was here, right? So again, this is not something I can explain as much, But insist on using objective criteria is essentially putting things into perspective and not making it a personal thing. So this approach is referred to as being hard on the merit and soft on the people. Because the first thing we do is separate the people from the problem. The problem is not against you. It's against this issue that we have, right? And when you come together, you are being hard on the merit. Then the advantage requires a negotiator to be fair while also protecting them against any people who might take advantage of the fairness. So to put the objective criteria into perspective, let's say you go out and you say, well, mom, you say to your parents, well, I want to have alcohol in a Muslim household. Then they would use an objective criteria to negotiate with you. Well, no, no son, no daughter, this is not what we do, right? This is the objective criteria that the society has set for Muslims or has been set by God for us. And then I'm going to make you stand on that criteria. So no, when negotiating with you, the parents are going to use that objective criteria that is out there in our religion. But again, recommended reading, Getting to Yes by Roger Fisher and William Ury. It's this book right here. If you want to or take a screenshot of something, I have the title in the slides as well. Amazing book, a must-have and a must-read for negotiators and negotiators of all kinds. Whether it's low-level negotiations such as everyday negotiations that we have in our lives, personal relationships, or if it's diplomatic affairs, then I think this would be the starting point for the negotiators. And it's really an easy book. They haven't used any technical language as such, and this is the book that they teach you in the Harvard program on negotiation. So there's that. So if we compare the three approaches, here's a comparison. That's the page 13 that I have pasted from Getting to Yes there. So in soft, if both the negotiators are soft, the participants are friends. If they are hard, they are adversaries. If they use principled negotiation, they would be problem solvers, as we discussed before. For soft negotiators, the goal is agreement. For hard negotiators, the goal is victory. For principled negotiators, the goal is a wise outcome reached efficiently and amicably, right? So we have all these comparisons that you can, in your own time, go through from the presentation and look at how these things compare to the soft and hard approach. Another one again, so soft negotiators would change their position easily. The hard negotiator would dig into their position, whereas the principal negotiator, would focus on the interest. So they would not. So the position is, I want an orange. The interest is, I want an orange because I want to make the marmalade, right? Or I want to make the juice. So you separate the position from the interest. That's how you negotiate principally. That's what the Harvard negotiation project is about, right? So again, all these things insist on using objective criteria, try to reach a result based on a reason, standards independent of will, reason and be open to reason, yield to principle, not pressure, develop multiple options to choose from, decide later, avoid having a bottom line, proceed independent of trust, and be soft on the people, hard on the problem. So these are some of the advantages you have in comparison to the soft and hard negotiators to the principal negotiation method as we discussed earlier. This brings us to the next point, next topic, which is mediation. So mediation essentially is, as I have put there, the art of facilitated negotiation by a third party neutral who facilitates communication between parties to assist them in resolving their disputes in an amicable manner. To put that in a nutshell, where another person who is a neutral comes in to assist both of you to negotiate, that's what a mediation is. So here, where two siblings are fighting, the dad comes in and he listens to both of you and he tries to solve it for both of you. That would be a sort of mediation. Not exactly mediation, and why that's not mediation is something we'll look at later. But that's a type of mediation, or you can even put that into conciliation. But it would be something on similar lines. Or let's say where the role of union councils in marriages in Pakistan, so where they act as a neutral in facilitating both of you to not ruin your marriage, or whether you want to have a divorce or not. That's where they operate as a neutral. The parties are empowered to decide the outcome of the disputes themselves. So in mediation, the distinguishing factor here is the parties are empowered, right? In litigation, it's not the will of the parties, it's the will of the judge. The parties put their case, the judge decides it for them. Mediation, it's a form of facilitated negotiation. The parties are going to be facilitated by the mediator to decide what to do. Now, in doing that, the mediator is not going to make any judgments or give any suggestions here, right? And that's the key point which I want you to hold on to. The mediator does not make any suggestions to the parties or give their own will or give their own point of view. The mediator stands as a neutral who simply facilitates communication between the parties, right? And essentially looks at it from a bird's eye view. And through their questioning, they guide the parties to a point where they can resolve it. So again, the lack of decision-making power with the mediator. There is no decision-making power with the mediator, but that should not be confused with the fact that mediation is not by saying that mediation is not a binding process. It is a binding process if you reach an agreement. Otherwise, it's not. But the mediator cannot impose any judgments or their point of view on you. So the parties make decisions. That's where the voluntariness comes in. There are two types of agreements in mediation. So there's firstly the agreement to mediate. So this is the agreement which the parties sign before entering a mediation. It's essentially a confidentiality agreement. And there's some other clauses in that that the parties will not, the mediator cannot serve as a witness and so on and so forth. Then there's the mediated agreement. So that is essentially the settlement agreement, as some people refer it to. That is the agreement that the parties enter into voluntarily after mediating their dispute at the end of the negotiation, right? The mediated agreement is enforceable in the court of law. Mediation can be ad hoc or institutional. So again, the agreement is binding if you reach one. You are not forced to reach one. It's your voluntariness whether you want to or not. The mediator is going to facilitate you. But if you reach an agreement, you sign it, it is witnessed, a test, and then it is going to be, you have the formality requirements, which we will look at later, then it is going to be enforceable. Mediation can be ad hoc or institutional. So you can refer to an institutional mediator. You can refer to, let's say, the CIR, CICA, ADR, ODI International, ICTRL, many institutions, or then you can either have a private mediator, a private practice mediator who can help the parties resolve their disputes. I see a hand was raised up. I'm sorry, we would take questions towards the very end. We have a lot of material to cover, but I will be leaving at least 15 minutes for all of your questions. So if you have something, please note it down, and I would make sure to address them. Mediations can include counsels or can be conducted with only the parties present. Again, that's where the cost-effective things come in. You don't need always a lawyer in your mediation, and that's where the legal industry feels threatened that, oh well, you are taking out the role of lawyers from mediation. No, that's not the case. The lawyers are still going to be involved when it comes to the enforcement of the mediation agreement, but it's the free will of the parties whether they want a lawyer or not. It can be having counsels, it cannot be having counsels. It's up to the parties. Early intervention and late intervention. There's 2 points at which you can have mediation. So it's early intervention. So let's say you have a small fight, you refer to a mediation. You have a disagreement, you go on and you mediate. You have an issue which you think may escalate and cause problems for your future relationship of the parties. You go in, you figure it out in the mediation. That would be early intervention, or as we refer to it, proactive mediation. There's also another way which you can resolve, another time which you can refer to mediation at, and that's the late intervention and reactive mediation, as we call it. Now, when that happens is when you have a litigated case, right? Everything is messed up, the parties are in court. Now, if at that point when the parties are in court and you refer the dispute to mediation, then that would be reactive mediation. You would be reacting to the issue that you have that led to the problems to escalate, and now you have that in mediation. Again, no requirement for the neutral to be a lawyer. So an engineer, if trained, can mediate an issue, and there's no as such requirement to have a license or go through training to mediate. But if you want to mediate officially with the high courts of Pakistan or institutions, then you need to be trained and trained really well But again, anyone can be a mediator. It can be your local Maulvi, it can be your religious leader, it can be your anyone who is essentially just a neutral. This is where mediation again offers an advantage that, let's say, so the judge knows the law, right? But the judge doesn't know about the technicalities of, let's say, making a bridge. They don't know about the material of that, right? Obviously, they can research, but that's again time consuming, and that's the point why we have ADR to save the times of the court, right? So here, the mediator, let's say, if you have a very complex engineering dispute, you can have a trained engineer mediator, right? You can have a trained apologies for the disruption. Am I audible now? Right, perfect. Thank you. So, so I was talking about engineer. So you have a trained engineer. So if we talk about Mr. Hassan, who's one of the speakers tomorrow, he comes from an engineering background, but he's also a qualified lawyer, and he's an accredited arbitrator and has been trained well. So if an ideal person to have for your complex engineering disputes, as opposed to having a judge decide it, because again, I'm sorry, I'll share this slide. Because again, they can research on that, but I don't think just like I don't think that it would be justifiable to only go to a person who does not have so much in-depth knowledge of engineering when you already have a person who has in-depth knowledge, right? So again, that's no requirement for the neutral to be a lawyer. Again, the counsel may accompany the parties to a mediation or can take place without the presence of the counsel. So how then you start a mediation? Well, the parties can either resort to mediation through an express clause in their agreement. So that's what the commercial parties have. So they would have a multi-tier dispute resolution clause, negotiation, mediation, then arbitration. They would have it tiered down like that. Another way is the court may refer the parties to mediation, and that's essentially the approach people tend to take. That all right, let's go to court and let's see if the court refers us to mediation. But that again hampers the entire point behind coming to mediation, which is essentially saving the time of the court and resources. Another way is where one party requests the other to participate in the mediation, and that's how it generally takes place internationally. So you file, you request the other party formally through either your counsel or through a mediator which you have chosen to participate in the mediation, and the party they accept your offer, then you mediate it. Right, simple as that. You don't need the court to refer you to the mediation, but again, that is also one way the court can also refer you to mediation. Consent of both parties throughout the process is essential. So since mediation is a voluntary process, so the voluntariness is of paramount importance. You cannot force a party to be in a mediation. Yes, the court may compel the party to be in a mediation or to go to a mediation, but the court cannot force the parties to resolve the dispute only in mediation, right? So how the court does that is essentially they refer the dispute to mediation, and in order to compel the parties to participate in mediation, the court and try their best endeavors to settle the dispute, the courts generally throughout the world have this requirement that if the mediation is not settled, if the matter is not settled in mediation, then the mediator prepares a brief report and submits it to the court as to why the dispute was not settled, right? And then obviously the judge can look at why it was not settled and what was the situation, whether it was one party was being unfair, or whether one party was being a hard negotiator, or one party was forcing, or anything like that, right? So again, consent of parties throughout mediation is essential. So let's say here, Noman and I are the parties and Essen is our mediator today. So let's say 10 minutes into the mediation, I'm like, you know what, Essen, I'm out. I don't want to mediate anymore. I can simply walk away, right? So that's how it works here. The mediator, how can the mediator be appointed? Again, it can be either appointed by a prior agreement of the parties, so they may have a specific mediator in the agreement who they want to appoint, or a specific institution from whom they want to appoint a mediator, or even a specific process through which they would appoint the mediator. The mediator may be appointed by the court, such as is done in the court of mixed mediation, or it may be appointed by one of the parties, and the other party can then consent to that appointment, right? So let's say, again, Noman and I are here. Noman issues gives me an offer to mediate, and he says, well, I have chosen SN to be our mediator today. And I'm like, cool, let's mediate. I accept SN as the mediator, right? So we can then proceed. Or I could say, no, well, Noman, I want to mediate with you, but I don't want SN. Instead, I want Shehem to be our mediator, right? And Noman says, well, cool, let's have Shehem as the mediator. Or alternatively, we could say, well, you know what? Let's have SN and Shehem both as our mediators, right? So that we can have two mediators as well. So it's, again, a very flexible process. But now, one limitation that you have here is the conflict of interest. So again, it was explained very well by Ahmed, so I won't dive too deep into that, but that's where the third party has an interest in the outcome of the dispute, right? So let's say Noman and I are negotiating about a workshop with the law wit. The matter is related to conducting a workshop with law wit. And I propose that let's have SN as a mediator. Well, SN cannot be the mediator because he has an interest in the outcome of the dispute, right? Because he is the founder of Lawit, right? So any decision we reach is going to have an effect, and SN has an interest in that, so we cannot have him as the mediator, right? So that's the appointment and choosing the mediator in a nutshell for you. Some things to note about mediation, and again, these are some very important things, and I would urge you all to note them down. Mediator cannot serve as a witness in court proceedings, so that's the general rule, unless or until the law specific requires any such disclosure. So generally, that would be in cases of child abuse in some jurisdictions, rape in others, criminal activity in other jurisdictions. So that's where the bar is set. But generally, as a general rule, a mediator cannot serve as a court witness. The mediator generally, again, it differs from jurisdiction to jurisdiction, but it operates under the without prejudice rule. So by that rule, anything that has been said in the mediation cannot be used as an evidence in court proceedings. So anything from the mediation cannot be admitted in court as an admission of guilt or whatsoever. Another thing is to keep in mind that the mediations operate under the ambit of law. Therefore, generally, criminal offenses, which are offenses against the state, cannot be settled through ADR. And by ADR, I mean all these forms that we have here. But in Pakistan, the ADR acts that we have, the numerous ADR acts we have, make reference to resolution of criminal disputes through ADR as well in situations involving compoundable offenses, right? The compoundable offenses is essentially where the parties can essentially reach an agreement and forego the other party, right? So in those situations where the criminal offenses of that nature, the parties can resort to ADR. One thing throughout the world, which we have generally seen, is sexual harassment cases have been mediated, right? And personally, I think if you have a mediator who has those expertise, only then should sexual harassment cases be mediated, right? So a sexual harassment case, if let's say you want Noman or me or SN as a mediator in a sexual harassment cases, hell no, it should not be mediated. But let's say if we have just another mediator, let's say it's Fiza from YMF. She's a lady, right? She understands the pain a woman would go through. As long as she does not have a conflict of interest and she is able to really handle emotions in a harassment case, then she can be a mediator. Otherwise, personally, I think you should not mediate such issues. Only if you have top tier expertise, then you should. And that's where one of the ADR Act, specifically the ADR Act 2017, if I'm not mistaken, which applies to Islamabad, states that if one of the parties in a dispute is a female, then the mediator would be a female, right? And I think that becomes very important in sexual harassment cases. Moving on, Stages in a mediation. So there's multiple stages. There's the opening session where the parties introduce themselves, give their opening statements, tell what brought them to the table. The mediator gives his or her introduction. Then there's the agenda setting. So essentially, the agenda I set as I set in initially in the initial part of the presentation, where I told you that, well, this is what I'm going to be talking about. So it's always something that helps the parties remain focused. Then another thing you have is the exploration session. So this is where the parties talk about the issue, what happened, the things prior to the dispute and what led to the dispute, and ask any questions or clarify each other. Then there's the negotiation session where the parties negotiate on the terms of the settlement. If there is an agreement reached in the negotiation session, then there would be an agreement drafting session, which would be, if the mediator is a lawyer, they would draft it. Otherwise, both the counsels of the parties, if present, would draft it. And then there's the closing session where you obviously thank everyone, you all meet once again, sign the agreement, and so on and so forth. There's different types of mediation, and that's something I have not included in the slides, but you can note it down. The two main types are one is shuttle mediation, one is joint mediation. So in shuttle mediation, the parties do not sit together. You would have one party in one room, the other party in the other, and then the mediator would go to one party, listen to them, then come to the other party, listen to them, and would essentially, it's like a shuttlecock in badminton. The mediator is the shuttlecock, and the rackets are the parties. So here, and there, and then they would we have all those technical expertise through which you have the parties come to a point where they can have a joint session and reach an agreement. Then there's joint mediation, where all the parties sit together on one table and discuss it there. In such mediations, in joint mediations, the parties can also have private meetings with the mediator. And these meetings are referred to caucus and cross caucus. Caucus, firstly. So a caucus is a private confidential meeting with an added layer of confidentiality simply between the mediator, the party, and the counsel of that respective party. Right? Contrastingly, the cross caucus would be, firstly to talk about caucus a bit more. So generally we have this confidentiality layer around mediations, right? So anything said therein cannot be used outside or used as a witness in court or as an evidence in court, right? Then in caucus, there's another layer of confidentiality. So it's multi-tiered confidentiality, and that layer of confidentiality in the caucus stays between the mediator and the party in that caucus, right? So there's that, and whatever the party says to mediator in that caucus would not be shared outside of that caucus with the other party till the party explicitly allows the mediator to do so. Cross caucus, on the other hand, would be where, let's say, where either both of the parties are present alone with the mediator, or either both of the counsels are present alone with the mediator. So let's say you have two counsels, two parties, and party A says, well, your counsel is to the mediator, well, I feel like this is something private and I would want to discuss with party B alone without the counsels. So can we please have a cross caucus, right? So then both of the parties can talk. Otherwise, both of the counsels can also talk in the presence of the mediator alone. Again, some advantages of mediation: time effective. You don't have that filing time, delays that you have in courts generally. You have that confidentiality, the without prejudice rule that I mentioned. You have the procedure as flexible, so mediation can literally take place even online, in a hotel room, in an XYZ city, wherever both the parties are comfortable. It suits the needs of the parties. Again, very flexible, the timing, what you want to do. You don't have to come in wearing a black blazer as most of the lawyers tend to do it. You can simply, well, obviously you need to be formal, but you do not need to come in as lawyers there, right? It is a bit on the informal side, right? So don't come in wearing a three-piece suit. And the same applies to parties. You don't have the decorum that you have to maintain as you are in court, but there is still some level of formality there. Deadlocks can be avoided and resolved. So the mediators have such skill sets that, let's say both of the parties are hard negotiators. The mediators possess that skill set, where they can help the parties resolve their deadlock, right? Win-win outcome for all. So there's no winner or loser. So there's no winning party, no losing party in mediations. Both of them are winners. And this is a phrase I use to at the end of my mediation. Well, by coming and agreeing at this mediation table today, both of you are leaving as winners. Both of you are winning, and the only thing that is losing here is the dispute, the problem that brought you here. So congratulations to both of you for coming together and defeating that problem. Preserve the relationship. So a few days back, even I was in the model town court, and I saw this lady who was there for her family dispute, and she was crying. Right? That's what happens in courts. The courts do not have enough space for your emotions. The judge is not going to decide on your emotions. I'm sorry, he's bound by the law. Mediation, there's ample room for your emotions, right? Again, in child custody cases and family, divorce, civil matters, commercial matters, property disputes, really, you have so many things which you can do in a mediation that you cannot otherwise, and even sexual harassment cases. So we know how our system works here. We know the type of questions that are asked to sexual harassment victims in front of the open public in courts, right? Why not come to mediation and resolve it there, right? Let's say there was some behavior that the other party did, which made you feel not well or harassed for that matter. Why not come in a mediation and try to talk about it and resolve it like that first? And there you reach an agreement that, all right, you won't come near me and you will do this, you will do that, and you won't bother me again, as opposed to the girl going in court, which is generally not even done here. It's just, well, stay quiet. Or you go to court and then there you have that open public where you are asked all these idiotic questions for that matter, excuse my language there. So why not come to mediation and resolve these differences there, resolve these disputes there? But again, whether it should be done in sexual harassment, everyone has their own opinion. But definitely in family ones, you should do it, right? Personally, if one of my friends were having a child custody or any property or any such dispute where it's the family involved, I would not take them to court. I would take them to mediation. Again, anyone can be a mediator provided they meet a certain standard and do not have a conflict of interest. And it again proves to be effective in technical disputes such as complex engineering disputes or family cases. Enforcement of a mediated agreement. Again, they are enforceable in courts. If you reach an agreement, if you sign an agreement, and I will discuss how they're enforceable in the context of Pakistan a bit later. And another thing is that international mediation agreements are also now for commercial disputes enforceable internationally under the Singapore Mediation Convention. Now, this convention is analogous to the New York Convention on Enforcement of Arbitral Award, 1958, that you would listen about tomorrow in Engineer Haslan's presentation. But essentially, if you reach an agreement between two contracting states of the Singapore Mediation Convention, then that agreement would be enforced in courts throughout the world which have ratified this convention. But one thing here is that Pakistan has not signed this convention yet, but there are still 58 countries that have signed this convention, right? So internationally as well, mediation is reaching that point where international mediated agreements in commercial disputes only would be enforceable throughout the world. Now, remember I told you to hold on to this thing, whether a mediator can propose or not propose. So this is where I want you to dive a bit deep into that. So some argue that since the mediator knows the private or confidential information from each party, therefore they would be in a good position to suggest solutions to them. Now, I don't refute that. I agree that the mediator would indeed be in a good position to suggest solutions to them, but just because they're in a good position doesn't mean they should. The process of mediation requires the mediator to not give suggestions. It's about the parties, it's about the voluntariness of the parties, and it's literally 100% freedom, whatever you want to agree on. If you're happy, we are all happy. But then obviously there's limits, there's the smart testing, there's the objective criteria, all the skill set that the mediator uses to ensure that no unfair agreement is reached, or not even unfair, excuse me for that, no agreement that would not be possible to execute for that matter is not reached, right? So the mediator ensures all these things through the technical training, through the training that they have been through. Well, on the other hand, people argue that mediators should not propose solutions whatsoever and should only assist the parties in finding their way to a mutually acceptable solution and should facilitate communication. This is a school of thought that I belong to. The mediator, again, 100% voluntariness of the parties, and you essentially in mediation, it's literally like a therapy. It's not just about resolving the dispute as a mediator, for me personally. Let's say the two brothers came into a dispute about property. If I go in as a mediator, my job is not to just resolve that dispute about the property. My job is to bring the both brothers together. Remember, we talked about how there's a win or lose situation in courts. We want to avoid that, right? How do we avoid that? We change that win or lose to a win-win and allow the parties to progress their relationship in a better manner in the future, allow them to understand each other and work their way around these disputes. Now, how you would do that is something again you learn as a mediator. That's something that most of the mediation courses teach you how to do, repairing the relationship between the parties and dealing with the emotions. So that's the school I belong to. And if you think that a mediator should make suggestions, I think you should not refer to it as a mediator. You should refer to that person as a conciliator. And you should not take the dispute to mediation. You should take it to conciliation because that's the prime difference in conciliation and mediation. Now, there's other differences as well, but that's really the prime difference there. So again, conciliation is also a very old method of resolving disputes. In early 1900s, there were the government in the United States also made commissions of conciliation. There was the Conciliation Act in the late 1800s in the United Kingdom. So it has been formalized for the most last 200 years. So if I define conciliation there, so the conciliation is the art of facilitated negotiation by a third party neutral. Again, still here, it's exactly the same definition as mediation, right? While facilitating communication and dialogue. Again, same as mediation as we read before. But it's this italic word which is different. The conciliator makes suggestions to assist the parties in resolving their disputes. So this way, the opinion that we had here, that the mediator would be in a good position to suggest solutions, well, that is already catered into conciliation, in the process of conciliation. Now, why do you want to blur that distinction and have the mediator make suggestions? Let's not blur that distinction. Let's maintain that distinction because throughout the world, this distinction is maintained, and especially in the exit rules. And I will talk about the exit rules and how they start off with suggestions. They start off with this very point that a conciliator can make suggestions. And then developing on that, they have an entire framework where they differentiate mediation and conciliation, right? So from the outset, from the basic, let's keep the difference alive. Let's know that in mediation, you don't make suggestions. In conciliation, the conciliator may make suggestions or can make suggestions and should make suggestions if appropriate to assist the parties in resolving the dispute. It's essentially the same definition, except for making suggestions, same as mediation. Again, just like mediation, it can be ad hoc or institutional. Just like mediation, the conciliator lacks decision-making power, but may propose solution to the parties. That solution is not binding. The parties, again, it is the art of facilitating negotiation. It is still a voluntary process. The parties may listen to that proposal or may not listen to that proposal. But at the same time, it is a bit more formal than mediation. And the reason for that is the different schemes that we have, legislative schemes, and the different rules that govern conciliation. They differ from mediation throughout the world, not specifically in Pakistan, but throughout the world, there is a difference in the rules that you will see. But there's also the other similarities. So both mediation and conciliations are aimed at finding out solutions for disputes. Both are non-judicial and non-adversarial processes. So again, no one is going to decide the dispute. You're going to decide it for yourself. And there's going to be a win-win situation for both of you. There's no win-lose situation like both. Wherein the parties attempt to seek a solution to their dispute rather than competing against each other. So as I said, it's you against the problem. It's not you against each other, right? So there's conciliation and mediation. Then both methods are voluntary in nature, whereby the parties need to agree to mediate or conciliate. So again, just like any other ADR method, the parties need to agree to mediate or conciliate. It can be again by nature, by agreement, or it can be later through court and so on and so forth, as we discussed earlier in mediation, the three different ways in which conciliator and mediator can be referred to. Now, how is conciliation then different from mediation? Let's talk about that a bit more. So mediation, the third party facilitates dialogue and communication between the disputing parties and helps them, again emphasis on them, arrive at their own, again emphasis on their own solution without making any suggestions to them. Conciliation, the third party, while facilitating dialogue and communication between the disputing parties, makes non-binding suggestions which the parties may agree to. Right, so that's the key difference where I have added them into. So in essence, whether or not the third party can make suggestions or propose solutions, or if they only facilitate open communication and dialogue between the parties, are the prime difference between mediation and conciliation. Now, the mediator acts as a facilitator. So you facilitate communication, you facilitate dialogue. Conciliator acts as a facilitator and as an evaluator. So when you want to make suggestions, you would firstly evaluate the situation, evaluate the situation that the parties are in, evaluate the merits, demerits, and then you would make a suggestion, right? So that's where your role as an evaluator comes in. And that's a role which the mediator does not take up. So the mediator is a facilitator, and the conciliator is a facilitator and an evaluator. Again, to support this, the ADR Act of 2017, which again applies to Islamabad, in Section 2E, refers to the definition of conciliation. It's essentially the same as the ones we have discussed before. So conciliation is a process in which a neutral person encourages the parties to resolve their civil or commercial disputes voluntarily, including by advising on possible solutions and terms of settlement. Contrastingly, in Section 2I, it talks about mediation, where it says it is a process in which a mediator facilitates dispute resolution by encouraging communication and negotiation between the parties in order for them to arrive at a mutually satisfactory agreement. So, I previously mentioned that we want to, from the outset, maintain that distinction between mediation and negotiation, where we say that these are different methods. And that's primarily, again, I have an example from India here, where mediation is governed under the Code of Civil Procedure 1908, whereas conciliation requires an understanding and is governed under the Arbitration and Conciliation Act of 1996, right? So that's where you have the distinction between the two. So you should know that distinction and not confuse the two methods as a professional. And now that's very difficult for a mediator to not make suggestions, because you essentially see the solution in front of you, but that's your job as a mediator. And how you do that is something you would learn in one of the trainings that I would give to you later. In Pakistan, the different ADR acts contain provisions for both conciliation and mediation, and for most part, both possess a similar status under the act. But again, there are still differences in Pakistan as well. So from the outset, maintain that distinction between mediation and negotiation, and don't confuse the two. Conciliation under ICSID. So as I said before, it's the prime difference is making suggestions and then you build upon that. So under the ICSID conciliation rules, a request for conciliation may be submitted only where the disputing parties have consented to the ICSID conciliation. So that's how you, if you initially consented to ICSID conciliation in an agreement, only then you may submit a request for conciliation under ICSID. But as far as mediation is concerned, a request for mediation may be submitted without a prior written agreement to mediate. So again, that example, Noman proposes, Ghulam, I want to have an ICSID mediation with you. Well, we can have that. But if I say, no, Noman, let's have an ICSID conciliation, we can't, right? Because we did not have a prior written agreement. So the request for mediation contains an offer to the other party to mediate the disputed issues, which is transmitted by the Secretary General of ICSID to the other party, inviting them to state whether they accept or reject it. So again, ICSID Secretary General as a neutral would take Noman's offer or my offer to Noman, communicate it, and see whether the other party accepts it. If the other party accepts it within a certain time frame, would there be further proceedings in the mediation? Now, again, another key difference under the ICSID rules is a party may not unilaterally withdraw from conciliation once consent has been given. So remember, I said I can 10 minutes after coming into mediation, I can say, well, no, I'm out. I don't want to talk. Well, in conciliation, you can't do that under the ICSID rules. And ICSID, from the outset, keep in mind that it's a form of institutional ADR. So institutional mediation, institutional negotiation, and institutional mediations and negotiations are governed under the rules of that institution. And when we are looking at this slide, it's literally the gist of the rules and what the rules essentially say, what their position is on these issues. But a consent to mediate is required both initially and throughout the entire mediation process. So let's say 10 minutes in the mediation, I'm like, I'm out. Well, I can leave. If it's a conciliation, I'm sorry, I can't take 10 minutes, then I have to complete that process. So again, under the ICSID conciliation rules, the conciliation commission consists of an uneven number of conciliators, but the number of mediators and the method of appointment differs as far as mediation is concerned. So by that method, there would be either one or two mediators, and they would be appointed by party agreement. So let's say Noman and I say, well, let's have two mediators. We can have two mediators. Let's say Noman and I say, let's have one mediator. We can have one mediator. Let's say I say one, Noman says two. Well, there would be no agreement. And on that, the ICSID rules say that the mediator, there's a typo here. It's supposed to be 30 days, but it says 30 here anyways. So the mediators would be appointed within where there is no agreement between 30 days of the request of mediation. The number of mediators to be appointed would be one. And then Noman and I would enter into negotiations and reach an agreement on which mediator should we appoint, right? Moving on. The role of the mediator under the ICSID is I'm sorry, one second. Ehsan, Khansa, can you please make sure everyone else stays muted in the call, please? Thank you. So the role of the mediator under the ICSID regime is limited to assisting the parties in reaching a mutually acceptable resolution of all or part of the issues in dispute. Again, nothing new. On the other hand, the mandate of the Conciliation Commission is broader and includes an obligation to clarify the issues in dispute. So you clarify the issues under the ICSID as well. You clarify the issues, you evaluate, you propose solutions, right? Then in the absence of the one key difference again in under the ICSID regime as far as mediation and conciliation is concerned is this. So in the absence of an agreement between the parties, no information concerning the mediation will be published by ICSID on its website. However, in conciliation, the Secretary General of ICSID is required to publish the names of the parties and the basic case details on the ICSID website. Now, what is ICSID again? International Center for Settlement of Investment Disputes. And this is one of the many institutions that we have throughout the world for ADR, but it is one of the most well-respected ADR institutions throughout. And one fact about ICSID is where it assumes ICSID also conducts arbitration. And where one thing about ICSID is where ICSID assumes jurisdiction over a matter, no other institution in the world can assume jurisdiction on that. So ICSID has exclusive jurisdiction on matters, but again, that's something Mr. Hasnan will discuss tomorrow. But it is the premier institution for ADR throughout the world. So I have laid down the differences there under the rules of ICSID in front of you today. Advantages of conciliation, essentially the same as mediation, except for these two. So since the conciliator hears both the sides and knows their confidential details, Therefore, they would be in a better position than a mediator to propose solutions. So remember earlier we have those proponents who wanted to say, who said that the mediator shouldn't propose solutions because they know, well, that's one of the advantages of conciliation. The conciliator knows the parties, they know the secrets, they know the confidential information. So, well, that's one of the advantages we have in conciliation. So don't push us into that place where you want to blur that distinction. Another thing, the conciliator would be able to distill the issues from the emotions in the dispute and can propose how it can be practically resolved. So let's say you have a case of child custody. Now there's going to be a lot of emotions. The mother, again, very attached to the child, gave birth to the child. The father, well, worked hard for the child. Again, they have their own emotions and attachment to their child. Now, at such situations, their mind would be clouded. They would not be in a position where they can make as rational decisions as they would be able to when they are not under that stress, under that pressure of losing their child, losing contact with their child. Excuse me. So in such situations, the neutral, the conciliator, because they do not have that pressure on them about losing their child and all those emotions that they're going through, then they would be in a position where they can propose better solutions. And as we have that phrase in Pakistan, we say just बात free होके फैसला नहीं लेते या just बात मेरी और फैसला सही नहीं होता, right? So essentially, when you are filled with emotions, you cannot take the best decision. You have the solution in front of you, and you won't be able to look at it. You won't be able to appreciate the presence of that. So here, the conciliator can clarify and say, well, you have the solution right in front of you. Do it like that, and then the party would be like, oh my God, we didn't even think of that, right? So that's where conciliation comes in, and that's one of the key advantages. But again, for all of you who are going to go out and practice ADR, specifically mediation and conciliation, if you are the mediator, please remain a mediator. If you are a conciliator, please remain a conciliator and don't blur the distinction. And throughout the world, we have the different ADR mechanisms, ADR institutional rules, and they preserve a difference between mediation and conciliation. And again, if you do not follow that, then you are going to be in a breach of the standards set by the institution, and there will be repercussions for that. And you might even be stripped of your accreditation if, let's say, you start proposing solutions in a mediation. So there's that strictness throughout the world. So the ADR continuum, the fancy word we were looking at initially. So this is essentially a graph which towards the left, it shows informal methods of dispute resolution. Towards the right, it shows more formal methods. Towards the left, it's more consensual. Towards the more right, it's more adjudicative. Towards the left, it's maximum party autonomy. Towards the right, it's released party autonomy. Towards left, it's the parties who decide. The more it is towards the right, the neutral, the third person decides. So if we look at it here, we have negotiation, full control, most party autonomy. Parties decide, no one intervenes. Towards the right, well, the parties don't have anything to do here except for making submission, the neutral decides. Then we have arbitration here, where the parties do have some autonomy, agreement to arbitrate and everything. Towards left, we have facilitation. So let's start from left, in fact. So we have negotiation, informal throughout. Facilitation, again, a little bit more formal, but a person tries to facilitate both of you. And then we have mediation here. So the moment you cross this line and go towards the right, the parties do not have that decision-making power. If you move towards the right from this line, you're giving your dispute to be decided by a neutral. If you have it towards the left, you are going to decide it for yourself with the help of the neutral, right? So mediation stands here, and this is where conciliation would also stand. So mediation and conciliation are essentially theoretically the same, with one key difference: practically they are different, right? So that's where mediation would stand. Then we have early neutral evaluation, settlement conferences, summary jury trials, some things which Ahmed mentioned yesterday, and then towards right, arbitration and litigation, right? This is the ADR continuum. And when explaining what mediation is, I would urge all of you, the practicing of you professionals, to share this with the parties and explain to them that this is where you would have autonomy. The moment we cross this, we go to union council for arbitration, we go to court for litigation, you lose your autonomy. The judge is going to decide whether you are worthy enough of having your child, whether the merits are in your favor. Here you decide. You and the father decide, right? In in full spirit of your child's well-being. Come to mediation. Let's invite the other party. Let's have them sign the agreement. Let's mediate. Let's try to mediate and let's try to resolve this without it being turned ugly. Enforcement in Pakistan. So there's multiple ADR acts in Pakistan. There's the ADR Act 2017, applies to Islamabad, Punjab ADR Act 2019, later amended by the Punjab ADR Amendment Act 2023. There's the KPK ADR Act 2020, and there's numerous other ones. There's the ADR rules, and so on and so forth. But here I have just handpicked a few sections from the ADR Act 2017, which I personally, it is one of the ADR acts that I personally like. Again, there's the KPK ADR Act is again, all of them are equally really good, but I personally just handpicked these provisions from the ADR Act 2017. But these are not only exclusive to ADR Act 2017, and are also similar provisions are also contained in the other ADR acts that I have mentioned above, and even those I have not mentioned. So starting from the outset, Section 10(1) talks about how an agreement, a mediated agreement would be enforceable. So it says, and I quote, the mediated, in fact, that's not a quote, that's something I have paraphrased myself, and please excuse the typos there. But the mediated agreement duly witnessed and signed by the neutral, that is going to be the mediator, and the parties or their duly authorized representatives. So let me hold on to that for a second. So in mediation, the parties do not need to come in themselves as well. So please keep that in mind. The parties can choose to mediate or conciliate through councils as well, right? So that would be the duly authorized representatives of the parties or attorneys is required to be submitted to the court, which shall pronounce judgment and pass decree in terms of the settlement. So you send that mediated agreement to the court, you submit it to the court, and then the court would pass a decree in terms of the settlement. Section 10(4), it talks about in situations where the neutral was appointed by an ADR center. It says where the neutral was appointed by an ADR center, the mediated agreement duly witnessed and signed by the neutral and the parties or their duly authorized representatives or attorneys is required to be submitted to the said center, which shall submit the same to the court, which shall then pronounce judgment and pass decree in terms of the settlement. So the first one, Section 10(1), refers to ad hoc ADR, mediation and conciliation. The Section 10(4) refers to institutional one, where you have an ADR center who then submits the award, the mediated agreement, I'm sorry. Then Section 10(5), that's also about ad hoc. So Section 10(1) is also about ad hoc, and it's also about court and ex mediation. So where the court refers you to a mediator, right? Section 10(5) is just about ad hoc. It says where the parties themselves resorted to ADR and reached a settlement, they may make an application to the court to make the same rule of the court. The court is satisfied that the matter has been voluntarily settled. So you see that emphasis on voluntary. And the document recording the statement has been duly witnessed and signed by the parties, shall pronounce judgment and pass decree in terms of the settlement. Now, Section 11, it talks about the failure of ADR. So remember, I mentioned that in situations, the way in which courts compel the parties to go to ADR and not be a hard negotiator in ADR, while also not forcing them to settle in a way that is detrimental for them. That's where Section 11 comes in. So it says, where the efforts of the neutral fail to bring about a settlement between the parties, they shall submit a report. So they means the neutral to the court, which shall proceed with the case from the state it was referred to for ADR. This again applies only in situations where the parties were referred to mediation by the court, and then the court sees that was it one party who was being very hard or being trying to abuse the other party, or was it the other party just not listening? And Section 12 It talks about disclosures related to ADR, so where the ADR center was approached by the parties before the initiation of court proceedings, and the center failed to bring about a settlement. No legal proceedings shall be initiated by either party without intimating the court about the failure of the ADR. Again, self-explanatory, just talks about disclosure. Again, section 5. So this is the section that I was talking about earlier in relation to sexual harassment cases, where it says that where at least one of the parties are a woman, the neutral shall be a woman. And I completely endorse that. And in fact, a better position here would be in situations where you have such sensitive matters, it can be both a woman and a man, right? So both of the parties are feeling safe. Both of the neutrals, again, they do not have any decision-making power anyways. So choose the bestest of the caliber, the bestest mediators are there. If you don't have them, then don't refer such disputes to ADR. And Section 5 also states that where the parties do not agree on a neutral, the neutral shall be appointed by the court. That's really the enforcement in Pakistan in a nutshell. This again brings us to centers for ADR in Pakistan. These are some of the centers. There's others as well, but these are a few of the best centers out there. So there's the ICADRIP, International Center for Alternative Dispute Resolution and Prevention. It is based in Islamabad. Dr. Nuzul Paracha is a part of this center. Again, an amazing center for resolution of your disputes. Highly recommended. Once you get trained, do register yourself there, do make an application there. Then there's the International Center for Dispute Resolution in Lahore. This is headed by Ms. Sara Tarar at International College of Legal Studies. Again, she's one of my mentors from day one. She's the one who got me into ADR. Dr. Nuzul Paracha is someone who we all look up to as professionals, and really always ask her for help and try to learn from her. Then there's the Center for International Investment and Commercial Arbitration Pakistan, that's the CICA. And personally, there's this XYZ company that I won't name, and I went to sign an agreement with them. I was working there for a short while, and I was very happy to see that they contained a clause from CICA. So they were referring to all their disputes to CICA mediation and CICA arbitration, right? So again, it is based in Lahore. I personally do not know the founders, but I'm a member of their young arbitration group. So CICA, again, an excellent organization, an excellent company of professionals, definitely recommended. Then there's the Chartered Institute of Arbitrators. This is the an arbitral institution from that has been granted the chartered status in the UK, and a very well respected and renowned international institution in terms of ADR and not just arbitrators. And then they recently launched their Pakistan branch. So again, an amazing organization, and definitely recommended. Would highly recommend joining the same. And then our very own the Young Mediators Forum. So this is one of the only organizations that are working right now that is student led. They are going to start off with their training soon. So again, highly recommended. We have the founder Ahmed Ali Raza here today. Again, an amazing professional, amazing organization, really hardworking student, and in fact the only ADR student-led organization in Pakistan currently. There was the UCL ADRI, the Universal College ADR initiative that I was a part of 3 years ago, but then that did not go forward once I left the college. So this is the only branch. So all of the students out here, definitely reach out to Ahmed, reach out to Young Mediators Forum, and get yourself involved. Some suggested trainings for all of you. So these are the 5 trainings that I would personally recommend to you. And again, I do not get any commission or any advantages from the same. It's just that I have paid myself from them and I found them to be really amazing. So the first and the foremost is the civil/commercial mediation training accredited by IMI. That's the International Mediation Institute. That's the premier mediation organization in the world, based in The Hague, Netherlands. Then there's the Singapore International Mediation Institute based in Singapore. And then there's the Civil Mediation Council of the United Kingdom. All 3 accredit this 40-hour mediation course. It's done by ADR and ODR International UK. The lead trainer is Rahim Shamji, the founder. Amazing man, amazing trainer, amazing guy. They have these, the way they charge you for trainings is based on where you are currently, where you are a national of, let's say you are a Pakistani national, you won't pay the same price as a national of the United Kingdom would, because you have that disparity in your income and everything. So a Pakistani, Indian, Sri Lankan national, apologies for the disruption, would not pay the same price as the national of, let's say, United States or United Kingdom, in order to ensure equal treatment and opportunities for everyone. This course is done both in person and online. You can get in touch with them at info@adrodrinternational.com and register for this course. Then there's a second course, that is Mediation Skill Course by Edwards Mediation Academy. This course is only online, but again, amazing course. Bruce Edwards has an experience of conducting over 20,000 mediations. Yes, you heard me right. That's 20,000 mediations. Amazing professional, excellent course, highly recommended. Then there's the program on negotiation by the Harvard Law School. So that's where this book was based. And again, amazing course, but this course is a bit on the expensive side, and you won't need to travel to the US to be able to do that. And this is, again, an expensive course. So ideally do the first two first, and then think about the program on negotiation. But again, I would personally recommend that. And then for lawyers, for working counsels who might not want to work as a mediator, or those who would want to train as a mediator and would then also want to participate as counsel, there's the mediation advocacy course by the Edwards Mediation Academy. Now, the dynamics of a counsel in a mediation is completely different from the dynamics in a court and a litigation proceeding. And that is something which the counsels have still not understood in especially Pakistan right now. So for them, and you can't even blame them, right? We do not have any such courses where we teach them how to do it. So that's where Edwards Mediation Academy, the mediation advocacy course, steps in. Again, amazing course, Bruce Edwards. Cannot praise this course enough. Then there's the Executive Negotiation and Conflict Management Skills course, again by ADR International UK. That takes place in Dubai only, in person only, but again, an excellent way to learn and interact from the Guru, Rahim Shamji himself, and his amazing team, who Ms. Sara is also a part of, and definitely recommended. And by the way, Rahim Shamji himself is a graduate of this course, and he did this, I think, a decade or so ago, if I'm not mistaken. But yes, moving on, some tips for professionals moving on from this workshop here. Again, the first and foremost, receive accredited training from a recognized and a well-reputed organization. You don't need to have the fanciest and the most expensive training. ADR ODR International is the most economical one at the moment, and one of the best ones out there. It is internationally accredited. I would recommend that. But receive whatever training you receive an accredited one. Then list as a neutral with ADR centers, again, the ones I showed you before, and then there's plenty of others. Again, I won't say register for this one, don't register for that. We are all in this together, and I equally support every ADR institution out there in Pakistan, and I would want all of them to work together. And then empanel as a mediator with the High Court. So the High Courts have their accredited mediator scheme, which they would only obviously allow you if you are an accredited mediator. So get accreditation, list as a neutral with the center, and empanel yourself with your local High Court. And the starting point, just like we do when we graduate from the law school, take up pro bono cases. Start off from your home. When there's a dispute between your family, well, you are biased. Yes, you have that conflict of interest, but there's nothing wrong with practicing at home, right? So start off from your home, start off from your neighbors, start off from your surroundings, take up pro bono cases through your centers, develop those skills, firstly through the accredited training, and then utilize those skills, apply them practically, and then start providing services where you start for them. And then act as a counsel in negotiations, mediations, and conciliation, obviously after receiving training, and only after receiving training for acting as a counsel in these ADR forums. Then another way of polishing your skills and not to have them rusted is to train students in ADR. So get involved, train students, whether you charge them or do it for free, that's up to you. but train students and let them take the light forward. So train students in ADR, and the most important, advise clients. This cannot, ADR in Pakistan or any country would fail unless or until the lawyers advise clients to resort to ADR. So yes, we are in this together. So advise clients to resort to ADR. And again, this is not going to take your livelihood away from you. In fact, this is adding another way which you can make money. You don't have to go into the courts in 50 degrees wearing a suit and a tie. You sit in an air-conditioned room and you help the parties resolve the dispute there, right? You assist the party as a counsel in those proceedings and help them resolve a dispute. You sit there as a neutral and help them. So it's another way through which you can generate income. And then obviously when you have that agreement, then you go to court, right? So that's another way. So three ways through which you can then make more income as opposed to having your income which you already have being being affected negatively. Way forward for students. Again, the person foremost receive accredited training from a recognized and well-reputed organization. The students cannot register with the High Court and for most of the ADR centers, but still register once you get your licenses, register with the High Court, internet law firms, or with the lawyer with the thriving ADR practice, and accompany your senior and observe them in negotiations, mediations, and conciliations. Again, following the lead of the professionals, seeing them do their magic is the best way to learn. So do that. One of the most important things here is join student groups. So again, SICA has their young arbitration group, CIAB has their young members group, and the only young members group, YMF. Your very own YMF, join YMF, participate in their trainings. ICDRL, the International Center for Dispute Resolution Lahore, join them as students, as members, as interns, and have they are also going to conduct trainings. So their email is cdr@icls.org.pk. So reach out to them for trainings, reach out to Ahmad, reach out to YMF for trainings, join them, join hands with them, and you will receive plenty of opportunities there. And participate in ADR competitions. Encourage your universities, colleges to go into ADR competitions, train for those competitions, whether you want me as your trainer or you want anyone else as a trainer, I don't mind, but start participating in ADR competitions locally and globally as well. And for that, you can definitely always reach out to me. You have my number and email there. So I'll be more than happy and willing to assist students in getting trained for them. So this brings us almost towards the very end, where I'm going to address just some arguments against ADR. Again, this bias of ADR towards powerful was a topic that was mentioned by one of our colleagues yesterday. And these two are some topics that I found myself. So there was this argument yesterday that ADR might be biased towards the powerful. Yes, it might be, but the risk is minimal. And I've literally put all of my arguments there. So the risk is minimal as compared to the traditional litigation route. In ADR methods such as mediation, conciliation, the neutral lacks any decision making or imposing power on the parties. Then how can they be biased? How can the neutral be biased if they cannot force the parties to do something? Well, if you feel I am biased, just simply walk away, right? Or there's also under the institutions, there is also a mechanism and strict rules under which a neutral would be removed if they are not, if they are biased, or if a party says that they are biased, right? So you can make an application. If it's an institutional area, you make an application. Well, the neutral, I feel that the neutral is biased. But for the most of it, you can inform the neutral themselves in the proceeding that I feel that you are being biased, right? And the neutral would remedy that. And the reason why the neutral would be bound to remedy any such issues and take them into account is that in order to retain their accreditations under institutions such as IMI, CMC, CIMI, and CIAB, all these organizations have strict standards of neutrality, which, if not met, may lead to the title being struck off from and the neutral being struck off from the accreditation, right? And another point here is that let's say the reason why someone would say that I want Noman or Ehsan or Ghulam to be our mediators is because they would trust us. They would trust our neutrality. Now, if we start giving an impression where we are not neutral, then we won't get any more appointments, right? The neutrals are appointed based on their good standing and repute. In case of objections are raised to their neutrality and later proved, they would prove to be detrimental for their entire career ahead. Therefore, most neutrals would never, I personally would never take the risk of being biased towards one party or the other, because I want to have a long innings. I want to practice ADR for the rest of my career. So I'm not taking that risk where just for the sake of XYZ amount or for my relationship with XYZ party, I risk my entire career. Then there's the examples of the mediation rules. We have tons and tons of mediation rules which might be applicable to the dispute. And again, that's a choice of the parties, which chamber you refer to, which institution you refer to, or in case of ad hoc mediations or conciliations, you might also choose which rules would apply to your mediation. So there's the ICSID, ICC, UNCITRAL, BPO, LCIA, JAMS, HKIC, and then there's the domestic ADR rules in Pakistan as well. So under these, there's always provisions for neutrality and challenging where a neutral is not being neutral or biased for that matter. And then especially in Europe, you have the European Code of Conduct for mediators, right? So the mediators in Europe are supposed to adhere to this code of conduct, which if they do not, then there's severe consequences. There's going to be repercussions. And even I myself, if I am accredited with the IMI, CME, and CMC, I have these strict rules that I am supposed to meet. If I don't, and if let's say one of you complains to them that, well, this was the mediation and proves that this is why we feel, or let's say Adnan was biased, then that would have implications, right? Can you have this? So now my question here would be, with all due respect for the courts and the judges throughout the country, can you have this, and do you in fact have the same mechanism for the judges? Now that's a question I would leave for these people who say the ADR is or can be biased. It can be, but it can also be avoided. It can be addressed. The risk is minimal. Is that also the case in the court? That's a question that I'm leaving for you there. Then there's this argument that you need to come to the court in the end. Then why ADR? Well, it does make some sense, but not completely, because we never say that by coming to ADR, you don't need to go to court. From the outset, I have never even once said that. We always say that ADR reduces the burden on the courts and does not take it away completely from the courts, right? So aim of the ADR is not to replace the court system. It is to supplement it, to assist it in dealing with the shortcomings of the system. Our judges are overburdened. I have so many class fellows, so many colleagues whose fathers are judges. And whenever we sit with them, so I have this one friend, and even on Sundays, if I visit him, his father is working. If I visit him on the night, his father is working, right? So that's how much our judges and courts are burdened. So that's why we need ADR to supplement the system. And then all these arguments which Emma stated yesterday, they also stand. And then again, it is ultimately the courts that would enforce any ADR remedies. But the fact, Umer Ruqayya, I see your hand raised up. We just have 2 minutes till we wrap up the presentation, and then I'll open the floor for questions. The fact that it is ultimately the courts which would enforce any ADR remedies, but the fact that we do not have to burden and go through the entire process of the court deciding the dispute eases the burden on them. Yes, it is going to be the courts that are going to enforce it, but that burden is just going to be a simple application. A simple application, the court issues a decree, it is enforceable, simple as that, as opposed to taking dates, giving money to the lawyer, and then all the shortcomings of the system that we are all already aware of. And again, 2 hands are better than 1, right? So I think that's self-explanatory. And then there's another argument which I've heard from our distinguished. There's another argument that we have heard from our distinguished seniors who are of the view that you need to learn litigation first before learning and practicing ADR. With all due respect, yes, I agree that learning litigation can indeed add another tool to the skill set of the professional, whereby they can also take up enforcement proceedings. So if I don't know how to litigate a claim, or if I don't know how to file a claim in court for a case, then I cannot take up enforcement proceedings. So yes, litigation would be advantageous if I know as a lawyer, as an ADR lawyer, then that would be advantageous for me. But now this is where the but comes in. Learning litigation is not a prerequisite for practicing ADR. The dynamics are different. It's a different way of resolving. It's an alternate way of resolving. It's an appropriate, another appropriate way, however you want to term it, but it is different. So rather than what you need is learning and getting trained in different ADR techniques to be able to practice ADR. You don't need to learn litigation before you can practice ADR, right? You don't need to learn how to litigate before coming and learning about ADR or practicing ADR. Learn litigation while you learn ADR. Definitely, that's the best way forward. But simply learning ADR and being a neutral, that's also enough in my humble view. Issues in Pakistan, again, there's plenty, but some of them lack of awareness and training. So we misunderstand what ADR is. We seem to argue that ADR is takes away the burden from the court. It eases the burden, does not take it away completely. Training, most of the people here are not trained enough. They do not have awareness. They do not possess the skills, and that's why they do not refer the parties to ADR. That's where one of the key issues. And then misunderstanding what ADR is. Again, we don't know exactly what ADR is, so we misunderstand that and are not able to comprehend and suggest parties about that in the best manner as it should be. Attitude of the parties towards setting out of court, that is something I will discuss in just a second. But then again, the attitude of the lawyers towards ADR. If you do not let the parties don't know what ADR is if the lawyer does not suggest ADR, right? So you need to be the one who suggests ADR to the parties. And you have seen the advantages, in my view, for ADR. So another thing is attitude of the parties towards settling out of the court. And again, this is where the attitude of the lawyers come in. So if you're a lawyer of a party and your party is of the view that, no, I just want revenge. As we say, मैं उसको कचहरी में घसीटना चाहता हूँ. So we have that ego which some parties have. कि court में धक्के खाएगा तो पता लगेगा. If they go to court, then they'll find out, right? So this is where the lawyers step in. The lawyers then say, well, you want to do that, but I think it would be best for you to be able to resolve the dispute. And if the best advice I can give you in my capacity as a lawyer is if you resolve the dispute out of court through mediation or conciliation. Now, whether you want to do that is up to you, but we have these methods. This is the area continuum. These are the advantages, disadvantages, and then it's up to the parties whether they want to do it, right? That's how the attitude of the parties will also slowly condition and change towards settlement and ADR. And it's again, like I said, it's the lawyers who are going to be the people who are going to take this forward. It's not going to go forward unless or until the lawyers specifically suggest the parties to resort to ADR. And again, training, absolutely essential and necessary. Get yourself trained, get the accreditation. It's just like you spend on yourself in law school and get these fancy degrees and go for your LLMs. ADR is also an equally important, if not more, tool in the skill set and your skill set as a lawyer, as a professional, or even as a person. What better way and what better service to humanity can you do than to help them resolve their issues, their disagreements, and help them all relax and not have all these things to worry about. So this brings us to the end of the presentation. So thank you very much, everyone, for listening patiently. Thank you very much, Ahmed, Ehsan, the entire team at YMF, and the entire team at Lawwith for having me here for this presentation. It was a pleasure and absolute honor for me. If time permits, I would like to open the floor for questions. How we would proceed with that is please raise your hand and type. If you have any questions, you might also type them in the chat box or the YouTube, where I would require Ehsan or one of the people at Lawwith's assistance to read the question. So I would just give a minute or so for everyone to raise their hand. And then once that minute lapses, then we would take up all of your questions. But if you have any questions, please raise your hands right now so that we can divide time accordingly for all of your questions. Meanwhile, you have my number on the slide. You have my email. Please, I have shared my number, my LinkedIn, my email with you. I would expect all of you to have courtesy and not send pointless texts or some things like that. Not spam my WhatsApp. But in case there's a legitimate concern, legitimate question, or legitimate place where I can add value, then I would be more than happy and privileged to do that. I see 4 hands raised up here. And so let's first hear from Umme Ruqayya. Umme,
Assalamu alaikum, sir. Thank you so much for such an amazing lecture, and thank you for organizing such an amazing lecture for all of us. So I have an answer for you and a question as well. Yes, there is Supreme Judicial Council in the courts, where we can file our complaints against the judges who we think are biased based on our proofs. And other than that, I have a question that, as in the cases of sexual harassment, you personally supported mediation, but most people deny their charges against them, and they don't even take legal notices seriously issued by the courts. So, how to make a harasser agree to come and sit in the mediation and get to a solution? Kindly answer it. Thank you.
thank you very much for your input, Umme Ruqayya, and for your question as well. So firstly, to address your input, yes, there is a Supreme Judicial Council, but then again, the it's not as often or as easy as it is to hold a judge accountable, as easy as it is to hold a neutral accountable. And I'll leave that there. But again, thank you for your input there. As far as sexual harassment is concerned, now again, it is only where the alleged harasser agrees can there be mediation or conciliation. So you cannot make a harasser or anyone for that matter come in and stand in front of a mediation, right? So it's only where they agree, and then you can have them do that. So there's no way to force them. The only appropriate way, I think, is to first issue a mediation claim, to first issue a request for mediation. If they agree, and who wouldn't? Let's say if an XYZ person has a harassment allegation on them, why would they not want to mediate unless or until they are being complete idiots? And resolve it privately, because there is a chance that it was not intended, right? Let's say there is quite a chance that the allegation is something that they did not intend to do, or there could be anything where they felt that it was not their mistake, right? So in such situations, they would come into mediation and apologize, right? And not want that dispute to escalate. However, if they did it voluntarily, if they did it with intention, with mala fide, they would never come to mediation. And then you should also not bring them to mediation. Then I think the courts would be the most appropriate forum where they can be taken and it can be looked at. But again, you cannot force anyone for that matter to come in. I hope that answers your question. Momina. You're not audible. Momina, are you there? Since you're not audible, let's hear from Wajahat.
May I please?
Yes.
Thank you so much for educating us. Like in last, you used the word resolve the issues and disagreement for the sake of humanity. Like if I am not particularly from the law background or something like that, like what approach should I use to resolve the conflict between the common citizen or in my society? Like I take part in conflict at in my social circle and like this thing. Like what approach particularly I use? Hard, soft, or principle stance or according to the situation? Please educate us. Thank you.
Thank you very much, Vijahat, for your question. For me, it would always be principled. The reason being that it's a combination of both the approaches. Secondly, to dive deep and to understand more on that, I would advise you to read this book. It talks about your question, and this book is exactly on your question, and we'll address that in detail. But my answer to that question right away would be to take a principled approach of negotiation. And again, read this book then, and then obviously get trained as a mediator, whether you're from a law background or not, to dive deep and learn the practical technicalities on how to deal with that. I hope that answers your question.
Yes, thank you.
You're welcome. Law stairs.
Sir, am I audible now?
Yes, Momina, just give us a moment. We'll come to you in a
Okay,
moment.
okay. Thank you, sir.
You're welcome.
Assalamualaikum. Thank you for
Welcome.
information. And I have a question from sir, because sir, you think we have the court system like we have the age limited in our, what is the mediator age limited? If we have the become a court mediator, there are every person can be joined to be a mediator and conciliator. If there are no age limitation, would be any age limitation for the become a good mediator? Like we have the Supreme Court age limitation is 65 who become a judge. There is a age limitation of the meditation or conciliation. What do you think?
Right. Thank you very much for your question. And again, a very valid question there. This varies from high court to high court. I was reading these rules, which talked about the age limit of 35. So you need to be at least 35. But then there's other high courts which allow you, regardless of your age, to be empaneled as a mediator. So again, it varies from high court to high court and institution to institution. And for that, I would recommend that you refer to your respective high court, the ADR cells there, or the institution that you get yourself registered with. Refer to them, and they would then guide you accordingly whether you can, as a youngster, be empaneled as a mediator or not. As far as ADR ODR is concerned, they do not have a requirement of age. As long as you are trained well enough and pass the assessments, you can empanel yourself as a mediator there. And the same, I think, applies also to the CIR and the other organizations that I have talked about. But High Court, it varies. It varies for conciliators, mediators, and negotiators, and even arbitrators. So you would have to refer to your respective High Court for that.
Sir, it's I'm adding that point. If you have the festival my question, sir, you are saying that there are no age limitations, but it will be a same high court. If we are in our student, we are come in our final year for the degree, should we have the become a good mediator or not?
You can definitely become a good mediator at any age, provided that you work hard enough. But as far as the High Court are concerned, firstly, you cannot register as a mediator in the High Court unless or until you have a license to practice as an advocate. Secondly, once you have your license to practice as an advocate, then you need to follow the rules that respective High Court, the requirement that respective High Court has. Now, from High Court to High Court, हर High Court का अपना है, whether you can, let's say one High Court allows you to be a mediator only if you're 35 years of age, right? Otherwise, some others would allow you to be a mediator in any age, right? As long as, let's say, you're 18 plus. So it varies. For that, you would have to check with your High Court. आपको High Court जाके High Court से पता करना पड़ेगा कि क्या एज लिमिट आपने सेट की है जिसको मैं फुलफिल करके मैं मीडिएटर एम्पैनल हो सकता हूँ.
Okay, sir, it should be clear. Thank you.
Thank you. Momina.
Yes, sir. So I actually had two questions. The first question was, we talked about the element of confidentiality in mediation, right? So once the parties reach to a mediation agreement, they have to get it enforced through the court. So once it is passed as a decree, it becomes part of the public record. So does that not infringe the element of confidentiality for which the parties entered into mediation in the first case?
That's indeed a very well raised point, but so the agreement becomes a part of the public record, but it's just the agreement. It's not what led to the dispute. It's not the emotions of the parties. It's not all these other things. It's just that agreement. Now, how you reach that agreement? Let's say one party was crying throughout, right? Let's say one party does not have the money to go to court, or it could be anything, right? So those details, those private details, don't become a part of the public record. It's just that agreement. And while that might infringe on the principle of confidentiality, but I think that does it for good. And for most of the part, the private information stays confidential and cannot be used outside mediation, because your agreement does not state the reasons why you reached a particular agreement. It just says that the parties hereby agree, right? So I think it would not be hampering or going in contradiction of the confidentiality.
Okay, thank you, sir. And the other question was, you said that there can be more than one mediators, right? So essentially, a mediator is not supposed to give a decision, but at the same time, they have to basically engage the parties in a way that they come to a conclusion. So what if both the mediators, they don't agree upon a single approach? Then what is the remedy that is available to a party?
So again, this is where the professional conduct of the mediators come in. Let's say I have one approach and I let's say know Ahmed and he, let's say, has a different approach. Then I would not be a mediator with Ahmed. I will say, Ahmed, the party is going to appoint us, but I don't think we have a similar approach. So let's not take this mediation up together. Secondly, mediators, whenever it's about co-mediation, the mediators generally see and develop an approach. And when you get trained as a mediator in co-mediation, you learn how to work around your differences and not let that hamper your mediation, and not let your differences as mediators hijack your mediation. But otherwise, I don't think there's as such remedy in the law, and you don't even need any as such remedy in law, because even if the mediators have a different approach, that would hamper the process and would lead to no agreement at all, right? So why would you want to appeal it at all? So even if they have a different approach, it's up to the parties whether they want to reach an agreement. If you think they have a not so good approach, not the best approach, don't reach an agreement. Or you could ask for a replacement mediator. You could ask for another mediator if it's an institutional mediation. Generally, I think that would be the way to go about it. I hope that answers your concern.
Yes, sir. Thank you so much.
You're welcome. Bakhtiar.
Assalamu alaikum,
I'm
sir.
sorry if I pronounce your name incorrectly.
Am I audible?
Yes, you are.
Sir, I feel more comfort while asking my question in Urdu. So can I?
Yes, जी जरूर.
Sir, my first question, I have two questions. मेरा पहला सवाल ये है कि क्या मतलब जो है अवार्ड जो है वो अवार्ड आने के बाद में ऐसी कोई बाइंडिंग फोर्स है, बाइंडिंग है कि पार्टी पर, क्योंकि गिल्टी पार्टी आसानी से ये कहेगा कि ये मेरे खिलाफ है और उसको मतलब इन्फोर्स में नहीं लाएगा। तो जैसे कोर्ट का ऑर्डर या जजमेंट जो है कोर्ट का वो बाइंडिंग करवाती है पुलिस, तो ऐसे ही इसका आर्बिट्रेशन का कोई ऐसा फोर्स है जो आर्बिट्रेशन की डिसीजन को या अवार्ड को जो है वो इन्फोर्स करवाए?
हमारा आज का सेशन वो जो है वो प्राइमरीली मीडिएशन, नेगोशिएशन और कंसिलिएशन पे था, जिसमें
सर क्यों ये सवाल मेरा कल थे सर अहमद रजा से, और मेरा कुछ नेट का इशू था तो मैं उस हिसाब से ये सवाल नहीं कर सका। तो अगर आप आंसर दे सकते हैं तो मेरे लिए खुशी की।
इसके अंदर मैं इसको आंसर जरूर कर सकता हूँ, लेकिन अगर मैं वो कर दूंगा तो आप सबके जो कॉन्सेप्ट्स हैं वो थोड़े डिफरेंट हो जाएंगे, क्योंकि कल भी एक सेशन है और वो बहुत अमेजिंग स्पीकर हैं। तो अगर आप माइंड ना करें तो आप कल आके उनसे ये सवाल पूछिए, और लाजमी पूछिए, अच्छा सवाल है। और मेरे ख्याल से वो ज्यादा बेहतर पोजीशन में और ज्यादा एक्सपीरियंस रखते हैं इस सवाल को आंसर करने में।
अच्छा, और सर मेरा एक और सवाल,
लेकिन एक मैं आपको इनिशियल आंसर दे देता हूँ कि हाँ जी, बाइंडिंग फोर्स होती है इसके पीछे। पार्टी कोई भी ऐसे आके मुंह उठा के नहीं कह सकती कि मेरे खिलाफ है, मैं नहीं मानूंगी।
अच्छा सर, तो आर्बिट्रेशन के अवार्ड के आने के बाद भी तो गिल्टी पार्टी ये आसानी से कह सकती है, कोर्ट में जाने की रेमेडी तो उसके पास फिर भी होती है, तो वो फाइनली कोर्ट भी जा सकती है कि ये डिसीजन मेरे खिलाफ था, ये जो है ब्याज डिसीजन था। तो इस पे कुछ आप कहना चाहेंगे?
इसके अंदर फिर आपकी कोर्ट की अप्रोच आती है, जो कि पाकिस्तान की कोर्ट इस वक्त प्रो आर्बिट्रेशन है। कोर्ट पाकिस्तान की आसानी से आर्बिट्रेशन अवार्ड को नहीं सेटिसाइड करेगी। ठीक है।
जी जी
इसकी तरह मैं एक आपको जुरिस्डिक्शन की एग्जाम्पल अगर दूं, एक है बरमूदा, ठीक है।
जी सर।
वहां पे आपका एक भी आर्बिट्रेशन अवार्ड सेटिसाइड नहीं हुआ। जितने आर्बिट्रेशन अवार्ड है उन्होंने कहा करो एनफोर्स इनको, गए हो आर्बिट्रेशन में, आर्बिट्रेटर ने अवार्ड दिया, अब करो एनफोर्स। ठीक है। तो
जी
कोर्ट्स इतनी आसानी से, मतलब मजाक नहीं है कि कोई भी आके मुंह उठा के कह दे। कहती हैं पार्टीज बड़ा कुछ ट्राई करती हैं, लेकिन इतनी आसानी से होता नहीं है सेटिस्फाइड। हो सकता है लेकिन इतनी आसानी से नहीं होता।
और सर वन लास्ट क्वेश्चन,
हम्म।
हमें एडीआर की तरफ ही क्यों जाना चाहिए? कोर्ट में रिफॉर्म आनी चाहिए, कोर्ट सिस्टम को ठीक करना चाहिए, और जैसे कोर्ट्स के जो है केसेस जो पेंडिंग है वो जल्दी से जल्द हल हो सके। क्या आपने ये समझते हैं कि पाकिस्तान के कल्चर में एडीआर आम होने से एडवोकेट्स को नुकसान है, या एडीआर ठीक से तरीके से वर्क करेगी? क्योंकि मुस्लिम फैमिली लॉ ऑर्डिनेंस में एक प्रोविजन अवेलेबल है कि कोर्ट के ऑर्डर के बाद वो जो खुला के केसेस हैं वो यूनियन काउंसिल जाती हैं, और यूनियन काउंसिल मेडिटेशन के लिए यूनियन काउंसिल चेयरमैन के पास जाती हैं। तो वो भी अपना जो है ड्यूटी प्योरली जो है ना परफॉर्म नहीं करता। तो एडीआर में ये वर्क करेगी पाकिस्तान के कल्चर में, क्या आप समझते हैं? और इसके आने से जो है वकील हजरात पर या एडवोकेट्स पर कोई मतलब उनकी रोजी रोटी में कुछ कमी हो सकती है? क्या आप समझते हैं?
इसकी इसकी मैं, अब देखें, मैं फ्यूचर तो प्रिडिक्ट नहीं कर सकता यहाँ बैठ के, लेकिन मैं आपको पुरानी एक एग्जांपल दे सकता हूँ दो कंट्रीज
जी
की,
जी
जो कि
सर,
आपकी
बिल्कुल
इटली
बिल्कुल।
है और टर्की है।
जी
इटली और टर्की के अंदर पाकिस्तान से ज्यादा माड़ा हाल था। ठीक
जी
है,
जी
ज्यादा बुरे हालात थे वहां पे, और
जी
वहां पे एडीआर आम होने की वजह से अब बहुत हाई परसेंटेज केसेस बहुत आसानी से सॉल्व हो रहे हैं, उनकी कोर्ट्स बहुत एफिशिएंट हो गई हैं। ठीक है। तो आप इसको, क्वेश्चन को, अच्छा सवाल है, इसको रिसर्च करने के लिए रिफॉर्म्स, एडीआर इन इटली एंड एडीआर इन टर्की देखें, एंड वहां पे देखें कैसे उनका जुडिशियल सिस्टम भी कॉम्प्रोमाइज था, कॉम्प्रोमाइज इन द सेंस के इतना एफिशिएंट नहीं काम कर रहा था। तो रिफॉर्म्स आए, और रिफॉर्म्स एडीआर के थ्रू आए। और आपका यूनाइटेड किंगडम में भी वुल्फ रिफॉर्म्स में उसने क्या बात की थी, जब भी आप कोर्ट रिफॉर्म्स की बात करते हैं उसके अंदर आपका एडीआर एक बहुत इंपॉर्टेंट पॉइंट होता है। खाली जुडिशरी कैसे आप, अब आपके पास 5 लाख केस पड़ा हुआ है, आप क्या ही
जी
कर लेंगे कि आपका 5 लाख केस जल्दी से रिजॉल्व हो जाए? आप टाइम बार सेट कर देंगे, आप जजेस को ओवरबर्डन कर देंगे, आप कहेंगे जज 1 मिनट में एक केस फैसला करे, नहीं कर सकता। या आप क्या करेंगे, जजेस का नंबर बढ़ा देंगे, जजेस का नंबर बढ़ाएंगे, जजेस का कैलिबर गिर जाएगा। ठीक है। तो उसके लिए एडीआर आ जाता है आपका। तो उसके लिए डिटेल में जानने के लिए आप टर्की और इटली, इन दो जुरिस्डिक्शंस के बारे में एडीआर पे देखें, एंड आपको फिर पता लगेगा कि एडीआर सच में करता है, इट डज वंडर्स। इंडिया में भी किया
सर,
राइट
वो तो
अक्रॉस द।
यूरोपियन कल्चर है, लेकिन पाकिस्तानी कल्चर उसके
तो
बरक्स
इसीलिए
आप।
मैंने आपको इंडिया का भी एग्जांपल दिया। इंडिया के अंदर आपकी दिल्ली हाई कोर्ट ने कोर्ट नेक्स्ट मीडिएशंस बनाई हैं, तो आप इंडिया के अंदर दिल्ली में स्पेशली और डिफरेंट सिटीज में इंडिया कोर्ट नेक्स्ट मीडिएशन आप सर्च करें, स्टैटिस्टिक्स देखें, हमारा सेम
जी,
कल्चर है इंडिया से। तो वहाँ पे देखें, वहाँ पे बहुत फर्क है। ठीक है।
अच्छा अच्छा, थैंक यू सर, थैंक
You're welcome. Ehsan, do we have any questions from YouTube that you might want to bring up? Ehsan?
Yes, yes, sure. If only if you are comfortable answering them.
I am more than happy to. Meanwhile, if you have not typed any question on YouTube or in the chat box, please feel free to leave the meeting, I believe. I'm right, Ahmed?
So there are few questions from YouTube. If I just can put in.
Yeah, sure. Please
So
go ahead.
the first one is, it is related to the jurisdiction of ICSID. So
Mhm.
Varda has asked, is it obligatory for parties to consent to ICSID for conciliation at the time of agreement only? या फिर ये लोग बाद में भी कर सकते हैं?
So if I understand the question correctly, question ये है कि क्या एक्सिट की कंसिलिएशन के लिए स्टार्टिंग में ही कंसेंट करना जरूरी है या बाद में भी कर सकते हैं, राइट?
It is. Yes.
एक्सिट के लिए जनरली रूल्स आपके यही कहते हैं एक्सिट के, कि पार्टी से एग्रीमेंट होना चाहिए रिटन पहले से, टू बी एबल टू कंसेंट टू कंसिलिएशन। बाद में आप नहीं कर सकते जनरली, बट देन ऑब्वियसली देयर इज वर्क अराउंड, बट जनरल रूल आपका यही है।
Perfect. Thank you so much, sir. The second question is from the chat box. It's from Fatma. She wants to ask how well can power disparities between parties be resolved through mediation? Are there any limitations to it?
पार्टी डिस्पैरिटी, अच्छा, इसके अंदर जो आपकी तो द good mediation courses have an aspect where they talk about the power disparity between parties, and they teach you how to resolve it. So talking about power disparity, let's say in sexual harassment cases, um, if you go through a specialized training which deals with such issues or such criminal nature ke offenses, there they have all these techniques that teach you on how to deal with power disparity. And again, all these other trainings, ADR, ODR, International Edwards Mediation Academy, all teach you about techniques on how to deal with power disparity. So yes, it can be catered to, and at times it can prove to be very beneficial throughout the process. So yes, there's techniques which I cannot discuss in the next 5 minutes, obviously. But yes, there are techniques which can help you resolve that power disparity, which the mediators do learn in their training.
Thank you so much, sir, for answering the questions. And there were a lot, but you answered them very kindly. So thank you so much. We would emphasize the rest of the question that you guys can reach out to sir. He has shared his LinkedIn profile and phone number, WhatsApp number as well. So I think we should now proceed towards the closing. Sansa, if you can please.
Yes, I'm audible. I think I'm audible.
Yes, you are audible. A bit slower, but
First and foremost, I would like to thank Sir Ghulam Mohammed. The session was really a success. I can certainly say that. So, having said that, I wanted to ask you a question as well. You mentioned about ADR Act 2017, and actually, I'm working on a research project on ADR as well. So, we do have Arbitration Act of 1940 in Pakistan. So, I wanted to ask you that whether mediation is sanctioned in Pakistan law, or is there any legal framework for mediation which prevails in each province of Pakistan?
And sorry,
So
can
if
you
you could
repeat
answer this.
the latter part of the question? Whether mediation is what?
Is sanctioned in Pakistan? Is there any specific legal framework for mediation only? Like we do have Arbitration Act. So I just wanted to know that is there any specific provisions or law for mediation or any law which prevails in each province of Pakistan?
Right. There's no specific law as such when it comes to mediation in Pakistan. It's generally under the ADR Act and under the ADR rules that mediation is catered to. Arbitration is a very technical process and it's very lengthy process as well. Not as lengthy, but very technical. And then it has that binding and decision imposing force to it. So that requires different acts and everything. Mediation is a rather simple process. Training as a mediator is a bit difficult and technical, but otherwise it's simple. So we do not have and do not in fact need any as such legislation that deals with mediation. And I don't think that throughout the world there are any such acts which specifically just deal with mediation as far as national laws are concerned. But there are definitely different institutional rules. So I mentioned SICA. SICA has its own mediation rules. The ICADRIP, they have their own. So yes, there's that. But generally in Pakistan, you don't have any such law which governs just mediation. I hope that answers your question.
All right, yeah. Thank you so much. Thank you so much for your time and for sharing your knowledge. So I think we need to say bye to all the participants now. It's too late. So see you all tomorrow.
yeah, thank you so much, sir. Thank you so much to all the participants for joining us today. And we look forward to the third and the last session tomorrow. Thank you so much, everyone.
Thank you very much for having me. Good luck, everyone. Take care, and I hope to see you all as practicing area professionals in the future. And hopefully, we can co-mediate someday. Thank you, Essen. Thank you, Emma. Thank you, Kamsa. Have a good evening. Bye bye.